Judgment. Q. When a criminal case is dismissed on nolle prosequi, can it later be refiled? 2003. Nolle prosequi means the formal notice of abandonment by a plaintiff or prosecutor of all or part of a suit or action. Answer. As a general rule, when a criminal case is dismissed on nolle prosequi, before the accused is placed on trial and before he is called on to plead, this is not equivalent to an acquittal and does not bar a subsequent prosecution for the same. Galvez v. Court of Appeals, October 24, 1994. Q. Before the arraignment for the crime of murder, the private complainant executed an affidavit of desistance stating that she was not sure if the accused was the man who killed her husband. The public prosecutor filed a motion to quash the information on the ground that with private complainant's desistance, he did not have evidence sufficient to convict the accused. On January 2, 2001, the court, without further proceedings, granted a motion and provisionally dismissed the case. The accused gave his express consent to the provisional dismissal of the case. The offended party was notified of the dismissal, but she refused to give her consent. Subsequently, the private complainant urged the public prosecutor to refile the murder charge because the accused failed to pay the consideration which he had promised for the execution of the affidavit of desistance. The public prosecutor obliged and refiled the murder charge against the accused on February 1, 2003. The accused filed a motion to quash the information on the ground that the provisional dismissal of the case had already become permanent. Was the provisional dismissal of the case proper? The provisional dismissal of the case was proper because the accused gave his express consent thereto, and the offended party was notified. It was not necessary for the offended party to give her consent thereto. Section 8, Rule 117. Resolve the motion to quash, 2003. The motion to quash the information should be denied because while the provisional dismissal had already become permanent, the prescriptive period for filing the murder charge had not prescribed. There was no double jeopardy because the first case was dismissed before the accused had pleaded to the charge. Section 7, Rule 117. Q. X. The accused in a homicide case before the RTC Dagupan City was personally notified of the promulgation of judgment in his case set for 10 December 1996. On said date, X was not present as he had to attend to a trial of another criminal case against him in Tarlac. The trial court denied the motion of the counsel of X to postpone the promulgation. Can the trial court also order the arrest of X? 1997. No. The trial court cannot order the arrest of X if the judgment is one of acquittal, and in any event his failure to appear was with justifiable cause since he had to attend to another criminal case against him. Q. AX was charged before the YYRTC with theft of jewelry valued at 20,000 pesos, punishable with imprisonment of up to 10 years of prison mayor under the revised penal code. After trial, he was convicted of the offense charged, notwithstanding that the material facts duly established during the trial showed that the offense committed was estafa, punishable by imprisonment of up to 8 years of prison mayor under this said code. No appeal having been taken therefrom, said judgment of conviction became final. Is the judgment of conviction valid? Is the said judgment reviewable through a special civil action for certiorari? 2004. Yes. The judgment of conviction of the theft upon information for theft is valid because the court had jurisdiction to render judgment. However, the judgment was grossly and blatantly erroneous. The variance between the evidence and the judgment of conviction is substantial, since the evidence is one for estafa while the judgment is one for theft. The elements of the two crimes are not the same. Lauro Santos versus People, January 29, 1990. One offense does not necessarily include or is included in the other, Section 5, Rule 120. The judgment of conviction is reviewable by certiorari, even if no appeal had been taken, because the judge committed a grave abuse of discretion tantamount to lack or excess of his jurisdiction in convicting the accused of theft and in violating due process and his right to be informed of the nature and the cause of the accusation against him, which make the judgment void. With a mistake in charging the proper offense, the judge should have directed the filing of the proper information and thereafter dismissed the original information. Section 19, Rule 119. Promulgation of judgment and sense of judgment in absentia. Q. Ludong, Balatong, and Labong were charged with murder. After trial, the court announced that the case was considered submitted for decision. Subsequently, the clerk of court issued them notices of promulgation of judgment, which were duly received. On promulgation day, Ludong and his lawyer appeared. The lawyers of Balatong and Labong appeared but without their clients and failed to satisfactorily explain their absence when queried by the court. Thus the judge ordered that the judgment be entered in the criminal docket and copies be furnished their lawyers. The lawyers of Ludong, Balatong, and Labong filed within the reglementary period of joint motion for reconsideration. The court favorably granted the motion of Ludong, downgrading his conviction from murder to homicide, but denied the motion as regards Balatong and Labong. Was the court correct in taking cognizance of the joint motion for reconsideration? No. The court is not correct in taking cognizance of the joint motion for reconsideration. Section 6, Rule 120 of the Rules of Court provides that if the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available against the judgment, and the court shall order his arrest. Henceforth, the court erred when it has entertained the joint motion for reconsideration with respect to accused Balatong and Labong who were not present during the promulgation of the judgment. The court should have merely considered the joint motion as a motion for reconsideration that was solely filed by Ludong, People v. Digrano, June 5, 2009. B. Can Balatong and Labong appeal their conviction in the case Ludong accepts his conviction for homicide? 2014. No. Balatong and Labong cannot appeal their conviction because they lost their right to appeal during the promulgation of judgment. Be that as it may, if they surrendered and filed a motion for leave to avail of their post-judgment remedies within 15 days from promulgation of judgment, and they have proven that their absence at the scheduled promulgation was for a justifiable cause, they may be allowed to avail of said remedies within 15 days from notice thereof. People v. Digrano, June 5, 2009. Search and seizure. Q. A PIDEA asset or informant tipped the PIDEA director, Shabunat, that a Shabu laboratory was operating in a house at Santa Cruz, Laguna, rented by two Chinese nationals, Hopia and Xiao Pao. PIDEA director Shabunat wants to apply for a search warrant, but he is worried that if he applies for a search warrant in any Laguna court, their plan might leak out. Where can he file an application for a search warrant? PIDEA director may file an application for a search warrant in any court within the judicial region where the crime was committed. Section 2, letter B, Rule 126. B. What documents should he prepare in his application for search warrant? He should prepare a petition for issuance of a search warrant and attach therein sworn statements and affidavits. C. Describe the procedure that should be taken by the judge on the application. The judge must, before issuing the warrant, examine personally in the form of searching questions and answers, in writing and under oath, the complainant and the witnesses. He may produce on facts personally known to them, and attach to the record their sworn statements, together with the affidavits submitted. Section 5, Rule 126. If the judge is satisfied of the existence of facts upon which the application is based, or that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the form prescribed by the rules. Section 6, Rule 126. Suppose the judge issues the search warrant worded in this way: People of the Philippines, plaintiff, criminal case number 007 for violation of RA 9165 versus Hopia and Chopao, accused. To any peace officer, greetings. It appearing to the satisfaction of the undersigned after examining under oath PIDEA Director Shabunot that there is probable cause to believe that violations of sections 18 and 16 of RA 9165 have been committed, and that there are good and sufficient reasons to believe that Hopia and Chopao have in their possession or control, in a two-door apartment with an iron gate located at Jupiter Street, Santa Cruz, Laguna, undetermined amount of shabu and drug manufacturing implements and paraphernalia, which should be seized and brought to the undersigned. You are hereby commanded to make an immediate search at any time in the day or night of the premises above described, and forthwith seize and take possession of the above-mentioned personal property, and bring said property to the undersigned to be dealt with as the law directs. Witness my hand this first day of March 2012, signed, Judge XYZ. Cite or enumerate the defects, if any, of the search warrant. 1. The search warrant failed to particularly describe the place to be searched and the things to be seized, Section 4, Rule 126. Number 2. The search warrant commanded the immediate search at any time in the day or night. The general rule is that a search warrant must be served in the daytime, Section 8, Rule 126, or that portion of the 24 hours in which a man's person and countenance are distinguishable. By way of exception, a search warrant may be made at night when it is positively asserted in the affidavit that the property is on the person or in the place ordered to be searched. Alvarez versus CFI of Tayabas, January 29, 1937. There is no showing that the exception applies. Suppose the search warrant was served on March 15, 2012, and the search yielded the described contraband, and a case was filed against the accused in RTC Santa Cruz, Laguna, and you are the lawyer of Chopao and Hopia. What will you do? If I were the lawyer of Chopao and Hopia, I would file a motion to quash the search warrant for having been served beyond its period of validity. Section 14, Rule 126. A search warrant shall be valid only for 10 days from its date. Thereafter, it shall be void. Section 10, Rule 126. Suppose an unlicensed Armalite was found in plain view by the searchers and the warrant was ordered quashed. Should the court order the return of the same to the Chinese nationals, 2012? No. The court should not order the return of the unlicensed Armalite because it is contraband or illegal per se. Pider versus Baudet, September 28, 2011. The possession of an unlicensed Armalite found in plain view is mala prohibita. The same be kept in custodia legis. Particularly of place to be searched and things to be seized, plain viewed situation Q. The search warrant authorized the seizure of undetermined quantity of shabu. During the service of the search warrant, the raiding team also recovered a kilo of dried marijuana leaves wrapped in a newsprint. The accused moved to suppress the marijuana leaves as evidence for the violation of Section 11 of the Comprehensive Dangerous Drugs Act of 2002, since they were not covered by the search warrant. The state justified the seizure of the marijuana leaves under the plain view doctrine. There was no indication of whether the marijuana leaves were discovered and seized before or after the seizure of the shabu. If you were the judge, how would you rule on the motion to suppress? 2008. The motion to suppress filed by the accused should be granted. The search warrant violates the constitutional and statutory requirement that it should particularly describe the person or thing to be seized. Section 2, Article 3, 1987. Constitution. The plain view doctrine cannot be invoked because the marijuana leaves were wrapped in newsprint. Besides, the marijuana leaves are not the subject of the search warrant. Q. Police operatives of Western Police District, Philippine National Police, applied for a search warrant in the RTC for the search of the house of Juan Santos and the seizure of an undetermined amount of shabu. The team arrived at the house of Santos but failed to find him. Instead, the team found Roberto Cu. The team conducted a search in the house of Santos in the presence of Roberto Cu and barangay official and found 10 grams of shabu. Roberto Cu was charged in court with illegal possession of 10 grams of shabu. Before his arraignment, Roberto Cu filed a motion to quash the warrant on the following grounds. 1. It was not the accused's name in the search warrant, and 2. The warrant does not prescribe the article to be seized with sufficient particularity. Resolve the motion with reason, 2005. The motion to quash should be denied. The name of the person in the search warrant is not important. It is not even necessary that a particular person be implicated. Mantaring v. Roman, February 28, 1996. So long as the search is conducted in the place where the search warrant will be served. Moreover, describing the shabu in an undetermined amount is sufficiently particular. People v. T. January 20, 2003. Q. A search warrant was issued for the purpose of looking for unlicensed firearms in the house of Asin, a notorious gun for hire. When the police served the warrant, they also sought the assistance of barangay tanods who were assigned to look at other portions of the premises around the house. In a nipa hut, 30 meters away from the house of Asin, a barangay tanod came upon a kilo of marijuana that was wrapped in newsprint. He took it, and this was later used by the authorities to charge Asin with illegal possession of marijuana. Asin objected to the introduction of such evidence, claiming that it was illegally seized. Is the objection of Asin valid? 2014. The objection is valid. The search warrant specifically designates or describes the house as the place to be searched. Incidentally, the marijuana was seized by the barangay tanods 30 meters away from the house of the accused. Since the confiscated items were found in a place other than the one described in the search warrant, it cannot be considered as fruits of an invalid warrantless search, the presentation of which as an evidence is a violation of petitioner's constitutional guarantee against unreasonable searches and seizure. Ruben del Castillo v. People of the Philippines. Besides, the search is also illegal because the marijuana confiscated in the nipa hut was wrapped in a newsprint. Therefore, the same cannot be considered validly seized in plain view. Abraham Milclat v. People of the Philippines, August 31, 2011. Remedies from unlawful search and seizure. Q. Hercules was walking near a police station when a police officer signaled for him to approach. As soon as Hercules came near, the police officer frisked him, but the latter found no contraband. The police officer told Hercules to get inside the police station. Inside the police station, Hercules asked the police officer, "Sir, may problema po ba?" Instead of replying, the police officer locked up Hercules inside the police station jail. A. If Hercules filed with the Ombudsman a complaint for warrantless search, as counsel for the police officer, what defense will you raise for the dismissal of the complaint? As counsel of policeman, I will raise the defense of presumption of regularity in the performance of duty. I can also raise the defense that the police officer has the duty to search Hercules under the stop and frisk rule. A stop and frisk situation must precede a warrantless arrest, be limited to the person's outer clothing, and should be grounded upon a genuine reason in the light of the police officer's experience and surrounding conditions to warrant the belief that the person detained has weapons concealed about him. Valdez v. People, November 23, 2007. The stop and frisk search should be used when dealing with rapidly unfolding and potentially criminal situation in the city streets where arguably there is no time to secure a search warrant. Stop and frisk searches, sometimes referred to as Terry searches, are necessary for law enforcement. That is, law enforcers should be given the legal arsenal to prevent the commission of the offenses. This should be balanced, however, with the need to protect the privacy of citizens in accordance with Article 3, Section 2 of the Constitution. People of the Philippines versus Victor Cogaid, July 30, 2014. B. If Hercules opts to file a civil action against the police officer, will he have a cause of action? 2015. Yes, Hercules has a cause of action to file civil action against the police officer under Article 32, Number 4, in relation to Article 2219, Number 6, and 10 of the new Civil Code, which provides that a police officer may be liable for damages when the right to be secure in one's person, house, papers, and effects against unreasonable searches and seizure is impaired. The indemnity includes moral damages. Exemplary damages may also be adjudicated. Galvante versus Casimiro, April 22, 2008. Evidence. General Principles. Q. Legislative Facts and Adjudicative Facts, 2004. Legislative facts refer to facts mentioned in a statute or in an explanatory note, while adjudicative facts are facts found in a court decision. Q. Give the reasons underlying the adoption of the following rules of evidence. Dead man rule. If death has closed the lips of one party, the policy of the law is to close the lips of the other. Coney versus Court of Appeals. This is to prevent the temptation to perjury because death has already sealed the lips of the party. Letter B. Parole evidence rule. It is designed to give certainty to a transaction which has been reduced to writing because written evidence is much more certain and accurate than that which rests on fleeting memory only. Francisco Revised Rules of Court. C. Best evidence rule. This rule is adopted for the prevention of fraud and is declared to be essential to the pure administration of justice. If a party is in possession of such evidence and withholds it, the presumption naturally arises that the better evidence is withheld for fraudulent purposes. D. The rule against admission of illegally obtained extrajudicial confession. An illegally obtained extrajudicial confession nullifies the intrinsic validity of the confession and renders it unreliable as evidence of the truth. It is the fruit of a poisonous tree. Letter E. The rule against the admission of an offer of compromise in civil case, 1997. The reason for the rule against the admission of an offer of compromise in civil case as an admission of any liability is that parties are encouraged to enter into compromises. Courts should endeavor to persuade the litigants in a civil case to agree upon some fair compromise. Article 2029, NCC. During pre-trial, courts should direct the parties to consider the possibility of an amicable settlement. Section 2, Letter A, Rule 18. Admissibility of evidence. Q. The barangay captain reported to the police that X was illegally keeping in his house in the barangay an Armalite M16 rifle. On the strength of the information, the police conducted a search of the house of X and indeed found said rifle. The police raiders seized the rifle and brought X to the police station. During the investigation, he voluntarily signed a sworn statement that he was possessing said rifle without license or authority to possess and a waiver of right to counsel. Individually rule on the admissibility and evidence of a rifle. The rifle is not admissible in evidence because it was seized without a proper search warrant. A warrantless search is not justified. There was time to secure a search warrant. People versus in C. Cada. Letter B. Sworn Statement 2008. The sworn statement is not admissible in evidence because it was taken without informing him of his custodial rights and without the assistance of counsel, which should be independent and competent and preferably of the choice of the accused. People v. Januario, February 7, 1997. Letter C. Waiver of right to counsel of X, 1999. The waiver of right to counsel is not admissible because it was made without the assistance of counsel of his choice. People v. Gomez, March 26, 1997. Q. Dominic was accused of committing a violation of the Human Society Act. He was detained incommunicado, deprived of sleep, and subjected to water torture. He later allegedly confessed his guilt via an affidavit. After trial, he was acquitted on the ground that his confession was obtained through torture, hence inadmissible as evidence. In a subsequent criminal case for torture against those who deprived him of sleep and subjected him to water torture, Dominic was asked to testify and to, among other things, identify his above said affidavit of confession. As he was about to identify the affidavit, the defense counsel objected on the ground that the affidavit is a fruit of a poisonous tree. Can the objection be sustained? Explain. 2010. No, the objection may not be sustained on the ground stated, because the affiant was only to identify the affidavit, which is not yet being offered in evidence. The doctrine of the fruit of the poisonous tree can only be invoked by Dominic as his defense in the crime of violation of Human Security Act filed against him, but not by the accused in a torture case filed by him. In the instant case, the presentation of the affidavit cannot be objected to by the defense counsel on the ground that it is a fruit of the poisonous tree because the same is used in Dominic's favor. Q. Sergeant Gr. of WPD arrested 2 NPA suspects, Max and Briggs, both age 22, in the act of robbing a grocery in Ermita. As he handcuffed them, he noted a pistol tucked in Max's waist and a dagger hidden under Briggs' shirt, which he promptly confiscated. At the police investigation room, Max and Briggs orally waived their right to counsel and to remain silent. Then, under oath, they freely answered questions asked by the police task officer. Thereafter, they signed their sworn statements before the police captain, a lawyer. Max admitted his part in the robbery, his possession of a pistol, and his ownership of the packet of shabu found in his pocket. Briggs admitted his role in the robbery and his possession of a dagger, but they denied being NPA hitmen. In due course, proper charges were filed by the city prosecutor against both arrestees before the MMRTC. May the written statement signed and sworn to by Max and Briggs be admitted by the trial court as evidence for the prosecution? 2004. No, the sworn written statements of Max and Briggs may not be admitted in evidence because they were not assisted by counsel, even if the police captain before whom they signed the statements was a lawyer, nor can he be considered as an independent counsel. Waiver of the right to a lawyer must be done in writing and in the presence of independent counsel. People v. Mahinay, February 2, 1999. Q. Defendant was declared in default by the RTC. Plaintiff was allowed to present evidence in support of his complaint. Photocopies of official receipts and original copies of affidavits were presented in court, identified by plaintiff on the witness stand, and marked as exhibits. Said documents were offered by plaintiff and admitted in evidence by the court, on the basis of which the RTC rendered judgment in favor of the plaintiff pursuant to the relief prayed for. Upon receipt of judgment, defendant appeals to the Court of Appeals, claiming that the judgment is not valid because the RTC based its judgment on mere photocopies and affidavits of persons not presented in court. Is the claim valid? 2000. The claim of defendant is valid because the court received evidence which it can order in its own discretion, in which case, the evidence of the plaintiff must pass the basic requirements of admissibility. Burden of proof and burden of evidence. Q. Distinguished burden of proof and burden of evidence 2004. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. Section 1, Rule 131. While burden of evidence is the duty of a party to go forward with the evidence to overthrow prima facie evidence established against him. See Bautista v. Sarmiento, September 23, 1985. Quantum of proof. Q. Distinguished preponderance of the evidence from substantial evidence. 2003. Preponderance of evidence means that the evidence as a whole adduced by one side is superior to that of the other. This is applicable in civil cases. Section 1, Rule 133. Substantial evidence is that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. This is applicable in cases filed before administrative or quasi-judicial bodies. Section 5, Rule 133. Judicial notice and judicial admissions. Judicial notice of foreign laws, law of nations, and municipal ordinance. Q. Give 3 instances when a Philippine court can take judicial notice of a foreign law. 1997. The 3 instances when a Philippine court can take judicial notice of a foreign law are: 1. When the Philippine courts are evidently familiar with the foreign law, Moran. 2. When the foreign law refers to the law of nations, and 3. When it refers to a published treatise, periodical, or pamphlet on the subject of law, if the court takes judicial notice of the facts that the writer thereof is recognized in his profession or calling as experts on the subject. Section 4 and 5, Rule 130. How do you prove a written foreign law? 1997. A written foreign law may be evidenced by an official publication thereof, or by a copy attested by the officer having the legal custody of the record, or by his deputy, and accompanied, if the record is not kept in the Philippines, with a certificate that such officer has the custody. If the office in which the record is kept is in a foreign country, the certificate may be made by a secretary of the embassy or legation, consul general, consul, vice consul, or consular agent, or by any officer in the foreign service of the Philippines stationed in the foreign country in which the record is kept, and authenticated by the seal of his office. Section 24, Rule 132. Salamea v. Court of Appeals. Q. Suppose a foreign law was pleaded as part of the defense of defendant, but no evidence was presented to prove the existence of said law. What is the presumption to be taken by the court as to the wordings of said law? 1997. The presumption is that the wordings of the foreign law are the same as the local law. Northwest Orient Airlines v. Court of Appeals. Object: real evidence. Chain of custody in relation to Section 21 of the Comprehensive Dangerous Drugs Act of 2002. Q. At the trial of Ace for violation of the Dangerous Drugs Act, the prosecution offers in evidence a photocopy of the marked 100 pesos bills used in the buy-bust operation. Ace objects to the introduction of the photocopy on the ground that the best evidence rule prohibits the introduction of secondary evidence in lieu of the original. Is the photocopy real, object evidence, or documentary evidence? The photocopy of the marked bills is real, object evidence, not documentary evidence, because the marked bills are real evidence. Is the photocopy admissible in evidence? 1994. Yes, the photocopy is admissible in evidence because the best evidence rule does not apply to object or real evidence. People v. Tandoy, December 4, 1990. Discuss the chain of custody principle with respect to evidence seized under RA 9165 or the Comprehensive Dangerous Drugs Act of 2000, 2012. In prosecutions involving narcotics and other illegal substances, the substance itself constitutes part of the corpus delicti of the offense, and the fact of its existence is vital to sustain a judgment of conviction beyond reasonable doubt. The chain of custody requirement is essential to ensure that doubts regarding the identity of the evidence are removed through the monitoring and tracking of the movements of the seized drugs from the accused to the police to the forensic chemist and finally to the court. People versus Sitco. Ergo, the existence of the dangerous drug is a condition sine qua non for conviction. People versus de Guzman. The failure to establish through convincing proof that the integrity of the seized items has been adequately preserved through an unbroken chain of custody is enough to engender reasonable doubt on the guilt of an accused. Nonetheless, noncompliance with the procedure shall not render void and invalid the seizure and custody of the drugs when 1. Such noncompliance is attended by justifiable grounds, and 2. The integrity and the evidentiary value of the seized items are properly preserved by the apprehending team. There must be proof that these two requirements were met before such noncompliance may be said to fall within the scope of the proviso. People versus De La Cruz. Rule on DNA evidence. Q. In a prosecution for rape, the defense relied on deoxyribonucleic acid, DNA, evidence showing that the semen found in the private part of the victim was not identical with that of the accused. As private prosecutor, how will you dispute the veracity and accuracy of the results of the DNA evidence 2010? As private prosecutor, I shall try to discredit the results of the DNA test by questioning and possibly impugning the integrity of the DNA profile by showing a flaw or error in obtaining the biological sample or in the chain of custody of the biological sample obtained, the testing methodology employed, the scientific standard observed, the forensic DNA laboratory which conducted the test, and the qualification, training, and experience of the forensic laboratory personnel who conducted the DNA testing. Q. At the public attorney's office stationed in Taguig, where you are assigned, your work requires you to act as public defender at the local regional trial court and to handle cases involving indigents. Still, in another case, this time for illegal possession of dangerous drugs, the prosecution has rested, but you saw from the records that the illegal substance allegedly involved has not been identified by any of the prosecution witnesses, nor has it been the subject of any stipulation. Should you now proceed post haste to the presentation of defense evidence or consider some other remedy, explain the remedial steps you propose to undertake. 2013. I will first file a motion for leave to file demurrer to evidence within 5 days from the time the prosecution rested its case. If the same is granted, then I will file a demurrer to evidence within 10 days from notice on the ground of insufficiency of evidence of the prosecution. Section 23, Rule 119. In People v. de Guzman, the Supreme Court held that in prosecution for violation of the Dangerous Drugs Act, the existence of the dangerous drug is a condition sine qua non for conviction. The dangerous drug is very corpus delicti of the crime. The identity of the prohibited drug must be established with moral certainty. Apart from the showing that the elements of possession or sale are present, the fact that the substance illegally possessed and sold in the first place is the same substance offered in court as exhibit must likewise be established with the same degree of certitude as that needed to sustain a guilty verdict. The corpus delicti should be identified with unwavering exactitude. Similarly, in People v. Sitco, the High Court held that in prosecutions involving narcotics and other illegal substances, the substance itself constitutes part of the corpus delicti of the offense, and that the fact of its existence is vital to sustain a judgment of conviction beyond reasonable doubt. Of chief concern in drug cases, then, is the requirement that the prosecution prove that what was seized by police officer is the same item presented in court. This identification must be established with moral certainty and is a function of the rule of chain of custody. The chain of custody requirement is essential to ensure that doubts regarding the identity of the evidence are removed through the monitoring and tracking of the movements of the seized drugs from the accused to the police to the forensic chemist and finally to the court. Documentary evidence Q. May a private document be offered and admitted in evidence both as documentary evidence and as object evidence? 2005. Yes. A private document may be offered and admitted in evidence both as documentary evidence and as object evidence. A document can also be considered as an object for purposes of the case. Objects as evidence are those addressed to the senses of the court. Section 1, Rule 130. Documentary evidence consists of writings or any material containing letters, words, numbers, figures, symbols, or other modes of written expressions, offered as proof of their contents. Section 2, Rule 130. A tombstone may be offered in evidence to prove what is written on it, and if the same tombstone is found on a tomb, then it is object evidence. It can be considered as both documentary and object evidence. See Gupit Jr., 1989. Best evidence rule Q. When A loaned a sum of money to B, A typed a single copy of the promissory note, which they both signed. A made two photo Xerox copies of the promissory note, giving one copy to B and retaining the other copy. A entrusted the typewritten copy to his counsel for safekeeping. The copy with A's counsel was destroyed when the law office burned. In an action to collect on the promissory note, which is deemed to be the original copy for the purposes of the best evidence rule. The copy that was signed and lost is the only original copy for purposes of the best evidence rule. Section 4, letter B, Rule 130. Can the photocopies in the hands of the parties be considered duplicate original copies? No. They're not duplicate original copies because there are photocopies which were not signed. Mahilam v. Court of Appeals. They constitute secondary evidence. Section 5, Rule 130. As counsel for A, how will you prove the loan given to A and B? 1997. The loan given by A to B may be proved by secondary evidence through the Xerox copies of the promissory note. The rules provide that when the original document is lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its contents by a copy or by its recital of its contents in some authentic document or by the testimony of witnesses in the order stated. Section 5, Rule 130. Rules on electronic evidence. State the rule on the admissibility of an electronic evidence. 2003. Whenever a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include an electronic document as defined in the rules. Section 1, Rule 3. Rules on electronic evidence. An electronic document is admissible in evidence if it is in compliance with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by these rules. Section 2, Rule 3. The authenticity of any private electronic document must be proved by evidence that it had been digitally signed and other appropriate security measures have been applied. Section 2, Rule 5. When is an electronic evidence regarded as being the equivalent of an original document under the best evidence rule? An electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means shown to reflect the data accurately. Section 1, Rule 4, 2003. Parole evidence rule. Pedro filed a complaint against Lucio for the recovery of a sum of money based on a promissory note executed by Lucio. In his complaint, Pedro alleged that although the promissory note says that it is payable within 120 days, the truth is that the note is payable immediately after 90 days, but that if Pedro is willing, he may, upon request of Lucio, give the latter up to 120 days to pay the note. During the hearing, Pedro testified that the truth is that the agreement between him and Lucio is for the latter to pay immediately after 90 days' time. Also, since the original note was with Lucio, and the latter would not surrender to Pedro the original note, which Lucio kept in a place about 1 day's trip from where he received the notice to produce the note, and in spite of such notice to produce the same within 6 hours from receipt of such notice, Lucio failed to do so. Pedro presented a copy of such the note, which was executed at the same time as the original and with identical contents. A. Over the objection of Lucio, will Pedro be allowed to testify as to the true agreement or contents of the promissory note? Yes, because Pedro has alleged in his complaint that the promissory note does not express the true intent and agreement of the parties. This is an exception to the parole evidence rule. Over the objection of Lucio, can Pedro present a copy of promissory note and have it admitted as valid evidence in his favor? Yes, the copy and the possession of Pedro is a duplicate original and with identical contents. Section 4, letter B, Rule 130. Moreover, the failure of Lucio to produce the original of the note is excusable because he was not given reasonable notice, as requirement under the rules before secondary evidence may be presented. Section 6, Rule 130, 2001 bar. Authentication and proof of documents. Q. X states on direct examination that he once knew the facts being asked, but he cannot recall them now. When handed a written record of the facts, he testifies that the facts are correctly stated, but he has never seen the writing before. Is the writing admissible as past recollection recorded? 1996. No, because the written record, to be admissible as past recollection recorded, it must have been written or recorded by X or under his direction at the time when the fact occurred, or immediately thereafter, or at any other time when the fact was fresh in his memory and he knew that the same was correctly written or recorded. Section 16, Rule 132. But in this case, X has never seen the writing before. Testimonial evidence. Q. For over a year, Nenita had been estranged from her husband Walter because of the latter's suspicion that she was having an affair with Vladimir, a barangay kagawad who lived in nearby Mandaluyong. Nenita lived in the meantime with her sister in Makati. One day, the house of Nenita's sister inexplicably burned almost to the ground. Nenita and her sister were caught inside the house, but Nenita survived, and she fled in time, while her sister tried to save belongings and was caught inside when the house collapsed. As she was running away from the burning house, Nenita was surprised to see her husband running away from the scene. Dr. Carlos, Walter's psychiatrist, who lived near the burned house, and whom Walter medically consulted after the fire, also saw Walter in the vicinity some minutes before the fire. Coincidentally, Father Platino, the parish priest who regularly hears Walter's confession and who heard it after the fire, also encountered him not too far away from the burned house. Walter was charged with arson, and at his trial, the prosecution moved to introduce the testimonies of Nenita, the doctor, and the priest confessor, who also Walter at the vicinity of the fire at about the time of the fire. 2006 and 2013 bar. May the testimony of Nenita be allowed over the objection of Walter? No. Nenita may not be allowed to testify against Walter. Under the marital disqualification rule, during their marriage, neither the husband nor the wife may testify for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Section 22, Rule 130. The foregoing exceptions cannot apply since it only extends to the criminal case of one spouse against the other, or the latter's direct descendants or ascendants. Clearly, Ninita is not the offended party and her sister is not her direct ascendant or descendant for her to fall within the exception. May the testimony of Dr. Carlos Wardle's psychiatrist be allowed over Walter's objection? Yes, the testimony of Walter's psychiatrist may be allowed. The privileged communication contemplated under Section 24, letter C, Rule 130 of the Rules on Evidence involves only persons authorized to practice medicine, surgery, or obstetrics. It does not include a psychiatrist. Moreover, the privileged communication applies only in civil cases and not in a criminal case for arson. Besides, the subject of the testimony of Dr. Carlos was not in connection with the advice or treatment given by him to Walter, or any information he acquired in attending to Walter in a professional capacity. The testimony of Dr. Carlos is limited only to what he perceived at the vicinity of the fire and at about the time of the fire. May the testimony of Father Platino, the priest confessor, be allowed over Walter's objection? Yes, the priest can testify over the objection of Walter. The disqualification requires that the same were made pursuant to a religious duty and joined in the course of discipline of the sect or denomination to which they belong, and must be confidential and penitential in character. Example, under the seal of confession. Section 24, letter D, Rule 130. Here, the testimony of Father Platino was not previously subject of a confession of Walter or on advice given by him to Walter in his professional character. The testimony was merely limited to what Dr. Platinus perceived at the vicinity of the fire and about the time of the fire. Hence, Father Platino may be allowed to testify. Competency versus credibility of a witness. Distinguish competency of the witness and credibility of the witness, 2004. Competency of the witness refers to a witness who can perceive and perceiving can make known his perception to others, Section 20, Rule 130, while credibility of the witness refers to a witness whose testimony is believable. Disqualifications of witnesses by reason of marriage. Q. Audie sued spouses Caesar and Baby for a sum of money and damages. At the trial court, Audie called Baby as his first witness. Baby objected, joined by Caesar, on the ground that she may not be compelled to testify against her husband. Audie insisted and contended that after all, she would just be questioned about a conference they had with the barangay captain, a matter which is not confidential in nature. The trial court ruled in favor of Audie. Was the ruling proper? Will your answer be the same if the matters to be testified on were known to Baby or acquired by her prior to her marriage to Caesar? Explain. 1998, 2000, 2004. No. Under the rules on evidence, a wife cannot be examined for or against her husband without his consent, except in civil case by one against the other, or in criminal case for a crime committed by one against the other. Since the case was filed by Audie against the spouses Caesar and Baby, Baby cannot be compelled to testify against Caesar without his consent. Lezama versus Rodriguez. Q. On March 12, 2008, Mabini was charged with murder for fatally stabbing Emilio. To prove the qualifying circumstance of evident premeditation, the prosecution introduced on December 11, 2009, a text message which Mabini's estranged wife, Gregoria, had sent to Emilio on the eve of his death, reading, "Honey, papatayin niyo ni Mabini. Matagal na niyang plano ito. Mag-ingat yu baka matsugi ka." A subpoena ad testificandum was served on Gregoria for her to be presented for the purpose of identifying her cell phone and the text message. Mabini objected to her presentation on the ground of marital privilege. Resolved. The objection should be sustained on the ground of the marital disqualification rule, Section 22, Rule 130, not on the ground of the marital privilege communication rule, Section 24, Rule 130. The marriage between Mabini and Gregoria is still subsisting and the situation at bar does not come under the exceptions to the disqualification by reason of marriage. Suppose Mabini's objection in question A was sustained. The prosecution thereupon announced that it would be presenting Emilio's wife, Graciana, to identify Emilio's cell phone bearing Gregorius' text message. Mabini objected again. Rule on the objection. The objection should be overruled. The testimony of Graciana is not covered by the said marital disqualification rule because she is not the wife of Mabini. Besides, Graciana will identify only the cell phone of that of her husband Emilio, not the messages therein, which to her are hearsay. If Mabini's objection in question B was overruled, can he object to the presentation of the text message on the ground that it is a hearsay? No. Gregorius' text message in Emilio's cell phone is not covered by the hearsay rule because it is regarded in the rules of evidence as independently relevant statement. The text message is not to prove the truth of the fact alleged therein, but only as to the circumstances of whether or not premeditation exists. D. Suppose that shortly before he expired, Emilio was able to send a text message to his wife Graciana, reading, "Nasaksak ako, di na mi makahinga. Si Mabini ang may gawa nito." Is this text message admissible as a dying declaration? 2010. Yes. The text message is admissible as a dying declaration since the same came from the victim who shortly expired, and it is in respect of the cause and circumstance of his death. The decisive factor that the message was made and sent under consciousness of an impending death is evidently attendant from the victim's statement, "Di na mi makahinga," and the fact that he died shortly after he sent the message. However, cell phone messages are regarded as electronic evidence, and in a recent case, Ang versus Court of Appeals et al., the Supreme Court ruled that the rules on electronic evidence applies only to civil actions, quasi-judicial proceedings, and administrative proceedings, not to criminal actions. Q. On August 15, 2008, Edgardo committed estafa against Petronilo in the amount of $3 million. Petronilo brought his complaint to the National Bureau of Investigation, which found that Edgardo had visited his lawyer twice, the first time on August 14, 2008, and the second on August 16, 2008, and that both visits concerned the swindling of Petronilo. During the trial of Edgardo, the RTC issued a subpoena ad testificandum to Edgardo's lawyer for him to testify on the conversations during their first and second meetings. May the subpoena be quashed on the ground of privileged communication? Explained 2008. No, the subpoena may not be simply quashed on the allegation that the testimony be elicited constitutes privileged communication. It may be noted that the accused committed the crime of swindling on August 15, 2008, whereas he first visited his lawyers on August 14, 2008, or before he committed the swindling. Clearly, the conversations the accused had with his lawyer during such first visit before he committed the swindling cannot be protected by the privilege between attorney and client because the crime had not been committed yet, and it is no part of the lawyer's professional duty to assist or aid in the commission of the crime, hence, not in the course of professional employment. The second visit by accused Edgardo to his lawyer the next day, August 16, 2008, after the swindling was committed, may also suffer from the same infirmity as the conversations had during their first meeting, inasmuch as there could not be complaint made immediately after the estafa was committed. The privilege covering a lawyer-client relation under Section 24, letter B, Rule 130 may not be invoked, as it is not a ground for the quashal of a subpoena ad testificandum under Section 4, Rule 21 of the Rules of Court. Although the subpoena ad testificandum may not be quashed, the privilege covers conversation with a view of professional employment. It can be invoked at the trial, but not quash the subpoena. Q. C is the child of the spouse H and W. H sued his wife, W, for judicial declaration of nullity of marriage under Article 36 of the Family Code. In the trial, the following testified over the objection of W, C, H, and D. A doctor of medicine who used to treat W. Rule on W's objections, which are the following. H cannot testify against her because of the rule on marital privilege. Answer. The rule of marital privilege cannot be invoked in the annulment case under Article 36 of the Family Code because it is a civil case filed by one against the other. Section 22, Rule 130. Letter B. C cannot testify against her because of the doctrine of parental privilege. Answer. The doctrine of parental privilege cannot likewise be invoked by W as against the testimony of C, their child. C may not be compelled to testify but free to testify against her. Section 25, Rule 130, Article 215 of the Family Code. Letter C. D cannot testify against her because of the doctrine of privileged communication between patient and physician, 1998. D, as doctor who used to treat W, is disqualified to testify against W over her objection as to any advice or treatment given by him or any information which he may have acquired in his professional capacity. Section 24, letter C, Rule 130. Q. Vida and Romeo are legally married. Romeo is charged in court with the crime of serious physical injuries committed against Selmo, son of Vida, stepson of Romeo. Vida witnessed the infliction of the injuries on Selma by Romeo. The public prosecutor called Vida to the witness stand and offered her testimony as an eyewitness. Counsel for Romeo objected on the ground of marital disqualification. Rule under the rules of court. Is the objection valid? No. While neither the husband nor the wife may testify for or against the other without the consent of the affected spouse, one exception is if the testimony of the spouse is in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Section 22, Rule 130. The case falls under this exception because Selma is a direct descendant of the spouse Vida. Will your answer be the same if Vida's testimony is offered in a civil case for the recovery of personal property filed by Selma against Vida, 2000? No. The marital disqualification rule applies this time. The exception provided by the rules is in a civil case by one spouse against the other. The case here involves a case by Selma for the recovery of personal property against Vida's spouse, Romeo. Q. XYZ, an alien, was criminally charged of promoting and facilitating child prostitution and other sexual abuses under Republic Act 7610. The principal witness against him was his Filipino wife, ABC. Earlier, she had complained that XYZ's hotel was being used as a center for sex tourism and child trafficking. The defense counsel for XYZ objected to the testimony of ABC at the trial of the child prostitution case and the introduction of the affidavits she executed against her husband as a violation of spousal confidentiality and marital privilege rule. It turned out that DEF, the minor daughter of ABC by her first husband, who was a Filipino, was molested by XYZ earlier. Thus, ABC had filed for legal separation from XYZ since last year. May the court admit the testimony and affidavits of the wife, ABC, against her husband XYZ in the criminal case involving child prostitution, 2004. Yes, the court may admit the testimony and affidavits of the wife against her husband in the criminal case where it involves child prostitution of the wife's daughter. It is not covered by the marital privilege rule. One exception thereof is where the crime is committed by one against the other or the latter's direct descendants or ascendants. Section 22, Rule 130. A crime by the husband against the daughter is a crime against the wife and directly attacks or vitally impairs the conjugal relation. Ordoña versus Daquigan, January 31, 1975. Q. John filed a petition for a declaration of nullity of his marriage to Anne on the ground of psychological incapacity under Article 36 of the Family Code. He obtained a copy of the confidential psychiatric evaluation report on his wife from the secretary of the psychiatrist. Can he testify on the said report without offending the rule on privileged communication, 2016? Yes, John can testify under the rule on privileged communication. The husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case filed by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Rule 130, Section 24, letter A. Rules of Court. In this case, Anne cannot prevent John from testifying against her, since the petition for declaration of nullity is a civil case filed by one spouse against the other. Hence, the rule on privileged communication between the spouses does not apply. John could testify on the confidential psychiatric evaluation report of his wife that he obtained from the secretary of the psychiatrist without offending the rule on privileged communication. Examination of a witness. Judicial affidavit. What are the contents of a judicial affidavit, 2016? A judicial affidavit shall be prepared in the language known to the witness, and if not in English or Filipino, accompanied by a translation in English or Filipino, and shall contain the following: A. The name, age, residence or business address, and occupation of the witness. B. The name and address of the lawyer who conducts or supervises the examination of the witness and the place where the examination is being held. Letter C. A statement that the witness is answering the questions asked of him, fully conscious that he does so under oath, and that he may face criminal liability for false testimony or perjury. D. Questions asked of the witness and his corresponding answers, consecutively numbered, that 1. Show the circumstances under which the witness acquired the facts upon which he testifies. 2. Elicit from him those facts which are relevant to the issues that the case presents. And 3. Identify the attached documentary and object evidence and establish their authenticity in accordance with the rules of court. Letter E. The signature of the witness over his printed name, and F. A jurat with the signature of the notary public who administers the oath, or an officer who is authorized by law to administer the same. Q. Pedro was charged with theft for stealing Juan's cell phone worth 20,000 pesos. Prosecutor Marilag at the pretrial submitted the judicial affidavit of Juan attaching the receipt for the purchase of the cell phone to prove civil liability. She also submitted the judicial affidavit of Mario, an eyewitness who narrated therein how Pedro stole Juan's cell phone. At the trial, Pedro's lawyer objected to the prosecution's use of judicial affidavits of her witnesses, considering the imposable penalty on the offense with which his client was charged. 2015. Is Pedro's lawyer correct in objecting to the judicial affidavit of Mario? Yes. Pedro's lawyer is correct in objecting to the judicial affidavit of Mario. The judicial affidavit rules shall apply only to criminal actions where the maximum of the imposable penalty does not exceed 6 years. Section 9, letter A, number 1 of AM number 12.8.9 SC, or the Judicial Affidavit Rule. Here, the maximum imposable penalty for the crime of theft of a cell phone worth 20,000 pesos is prison mayor in its minimum or medium periods, or 6 years and 1 day to 8 years and 1 day. Thus, Pedro's lawyer is correct in objecting to the judicial affidavit of Mario. Is Pedro's lawyer correct in objecting to the judicial affidavit of Juan? No. Pedro's lawyer is not correct in objecting to the judicial affidavit of Juan because the judicial affidavit rules apply with respect to the civil aspect of the actions regardless of the penalties involved. At the conclusion of the prosecution's presentation of evidence, Prosecutor Marilag orally offered the receipt attached to Juan's judicial affidavit, which the court admitted over the objection of Pedro's lawyer. After Pedro's presentation of his evidence, the court rendered judgment finding him guilty as charged and holding him civilly liable for 20,000 pesos. Pedro's lawyer seasonably filed a motion for reconsideration of the decision asserting that the court erred in awarding the civil liability on the basis of one's judicial affidavit, documentary evidence, which Prosecutor Marillo failed to orally offer, as a motion for reconsideration meritorious, 2015. No, the motion for reconsideration is not meritorious. The judicial affidavit is not required to be orally offered as separate documentary evidence because it is filed in lieu of the direct testimony of the witness. It is offered at the time the witness is called to testify, and any objection to it should have been made at the time the witness was presented. Section 6 and 8 of the Judicial Affidavit Rule. Since the receipt attached to the judicial affidavit was orally offered, there was enough basis for the court to award civil liability. Q. Aside from asking a witness to explain and supplement his answer in the cross-examination, can the proponent ask in redirect examination questions on matters not dealt with during cross-examination? 1997, yes. On redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court in its discretion. Section 7, Rule 132. Q. Aside from asking the witness on matters stated in his redirect examination, can the opponent in his recross examination ask questions on matters not dealt with during the redirect? 1997. Yes. The opponent in his recross examination may also ask questions on such other matters as may be allowed by the court in its discretion. Section 8, Rule 132. Q. After plaintiff has formally submitted his evidence, he realized that he had forgotten to present what is considered an important evidence. Can he recall a witness? 1997. Yes. After formally submitting his evidence, the plaintiff can recall a witness with leave of court. The court may grant or withhold leave in its discretion as the interest of justice may require. Section 9, Rule 132. Q. As counsel of an accused charged with homicide, you are convinced that he can be utilized as a state witness. What procedure will you take? 2006. As counsel for the accused, I will advise my client to ask for a re-investigation and convince the prosecutor for him to move for the discharge of my client as a state witness, or the accused can apply as a state witness with the Department of Justice pursuant to R.A. number 6981, the Witness Protection, Security, and Benefit Act. The right to prosecute vests the prosecutor with a wide range of discretion, including what and whom to charge. Sobrano v. People, October 5, 2005. Admissions and confessions. Q. A was accused of having raped X. Rule on the admissibility of the following pieces of evidence. An offer of A to marry X. A's offer to marry X is admissible in evidence as implied admission of guilt because rape cases are not allowed to be compromised. Section 27, Rule 130, People v. Domingo, September 8, 1993. A pair of short pants allegedly left by A at the crime which the court, over the objection of A, required him to put on, and when he did, it fit him well. 1998 Bar. The pair of short pants, which fit the accused well, is circumstantial evidence of his guilt. Although standing alone, it cannot be the basis of conviction. The accused cannot object to the court requiring him to put the short pants on. It is not part of his right against self-incrimination because it is a mere physical act.